Hey everyone, this is Megan.
And Darla. We are your hosts of the Enlighten Benefits podcast.
Our goal is to help you understand all things insurance. In each episode, we will tackle the confusing topics and terminology as it relates to insurance.
We want to create confidence over confusion and make insurance suck less.
We hope you enjoy our show. Hey, Darla.
Hey, Megan.
Woo, that was a little loud, wasn't it?
It was loud.
Hello.
That's my eardrum.
Hey, today in the studio, we have a special guest with us. We have Monica Maple. Hey, Monica.
Hey, how are you?
Wonderful. How are you?
Good.
Thanks for being here.
Yeah, thanks for having me.
So tell us who you are, what you do, a little bit about yourself.
My name is Monica Maple. I'm an attorney. I own Autumn House Estate Planning and Maple Law. We do mainly estate planning, trust, wills. We do probates, guardianships, and we do Medicaid planning.
Awesome. The whole getting old, you need Monica.
That's right.
Well, and anything and everything in between.
Right.
She's a good person to have in your hip pocket.
So,
Where are you guys located, Monica?
we are located at 420 Plaza Court in Sand Springs.
Okay.
We also have a satellite office in Eufaula, Oklahoma, and we have offices that we utilize in Tulsa, Catoosa, and Claremore and Bartlesville.
Wow. You are all over the place.
Everywhere.
Hey, Monica, if we have listening audience that is outside of the state of Oklahoma, do you practice outside of Oklahoma, or are you really focusing your market here in the state of Oklahoma?
Well, I cannot represent people in other states. I'm only licensed in Oklahoma.
Okay, good to know. Monica, we wanted to, we have lots of insurance questions as they relate to your field.
Okay.
So the first question we had for you is, Darla, when we're sitting down and visiting with people about life insurance, that question at the very end of the application, whether it's a group policy or whether it's an individual life insurance policy, I always get the question about the beneficiaries, that little box, don't you?
Yes, I would definitely say a good majority of the people don't really understand the repercussions of the choice of beneficiary, especially on life insurance.
Right.
Because, and it's my understanding that it's pretty much cut and dried. I mean, once you put that on there, it's pretty much in stone, unless you go back and change it.
That is correct. And the other thing I have people come and talk to me about is, oh, well, I'm going to leave Johnny as my beneficiary. He's my oldest and he'll split it with everyone else. Well, if you leave Johnny doesn't have an obligation to split it with everyone else. And a lot of times Johnny will not split it with everyone else.
That's a great point. So on most of our life insurance applications, it does have multiple lines on there. Right. So would that be your suggestion? If we have, so let's just use myself as an example. Life insurance, I'm married and I have 2 children. My kids are fairly young, 13 and 8. So would you suggest that I put Xander and Ella, my children, as my beneficiaries? Because Justin and I do travel, a lot together. So what would be your suggestion in a situation like that?
Well, the problem with naming minors as beneficiaries is that if you were to pass away while they were minors, it will be held in an account until they turn 18, unless a guardian is appointed for them. And then that guardian would have the ability to access those monies on their behalf under the guidance of the court.
Okay.
However, when those children turn 18, they would be entitled to all of those monies.
Okay.
And a lot of times life insurance policies are fairly large. And so giving an 18-year-old that kind of money at 18 is not always a wise choice. So what I usually recommend for something like that is a trust, because if you have a trust, you can control the money of your children until 21, 25, 30. Some even go on past that. You can have a third-party trustee give them money for their, whatever they need, health, education, maintenance, general welfare. Mm-hmm. If they are doing what they're supposed to do, they can help buy houses. They can provide for them without just cutting them a check when they turn 18.
Okay. So, I definitely want to get into that a little bit more because, I think that the thought process of most parents whenever you're purchasing a life insurance is, I want to make sure that my kids would be taken care of. As a participating breadwinner of the household, I would want to make sure that my kids are being taken care of. So just because we are listing our children as the beneficiaries, we may not actually be serving the purpose that we set out to serve. That's what I hear you saying.
Right.
Okay.
And if you set up a trust and other estate planning documents, you can name the guardian for your children. You can also name the trustee that would control their money. The other problem you have, and what you should do is if you have life insurance and you have a trust, then you should name the trust the beneficiary of that life insurance policy so that it then goes into your trust and is distributed to your beneficiaries according to your wishes.
So then they could indeed be quote unquote taken care of, meaning it's expensive, right? You're a mom too. It's expensive to raise kids.
Right.
So this would be a way for us to set up that trust and make sure that those monies could be available for them to continue to live life, right?
Right. And the other thing, just kind of throwing in there as well, is that a lot of the trusts that I do have built-in special needs trust. So if you have a special needs child and you leave money to them directly, you may disqualify them for certain benefits they're entitled to.
Oh, wow.
Especially once they turn 18, they may be entitled to certain benefits that they would not receive otherwise. And if they all of a sudden are entitled to monies that are left to them directly, it may disqualify them from those benefits.
Oh, that's a great point
That's a great point.
I never thought about. Yeah. We definitely need to tell our clients about that as we are going through. So Monica, let's say that we have taken the steps and we set up the trust, and then we, have set up who the trustee or, who's over the guardian of the situation. Then whenever we go and sit down and we're doing our life insurance, do we put the trust as the beneficiary, or how do we fill out that paperwork?
Yes, I would put the trust as the beneficiary.
Okay.
Most of the time, husbands and wives are going to set up joint trust. And so during their lifetimes, it would go for the benefit of your spouse. Okay. And then upon the death of your spouse or upon the death of both of you, then it passes to your children according to the terms of the trust.
Okay.
So I think one thing that we need to discuss here too, Megan, is that on the application, everybody also gets confused because, like you said, on the primary line, there could be like 4 lines there for primary beneficiary. And then there's also contingent beneficiary. You're probably going to get there, and I'm probably jumping ahead.
No, keep going.
But any person that you list on the primary line, if you list 4 people there, it's going to be divided equally between those 4 people.
Correct.
So a lot of times I'm just thinking of your case when you said Justin and I have 2 children.
Right.
Your main concern, because Justin would take care of your kids if something happened to you. So you would always want to make sure that you put Justin 100% as primary, and then do a guardian or a trust or, whatever as contingent, because in order for the contingent to receive the money, the primary would have to be deceased. So, and then, like you said, you travel together a lot. If something were to happen, then it would still pass to the contingent.
Now, Monica, if we set up the trust situation in that, like you said earlier, that most of the time a husband and a wife, they set that up together. So we could list in the trust that if something happened to me by myself, all of my assets would go to my husband.
Well, there's different ways you can do them. You can do some bypass trust, which is a little more complicated and usually for people that have more assets. But generally, when you do a joint trust, it's for both of your benefits. As long as you're both living. So for example, if you had life insurance and you named the trust the beneficiary of your life insurance policy, it would basically be your husband's and for his benefit during his lifetime. And then after something happens to him, then the provisions would kick in that whatever's in the trust would go to your children.
Okay. And it might be better to set it up like that. I'm just thinking for the tax implications, it might be better to pass that money through trust. That might be a whole different topic for another day.
Yeah. With this type of revocable trust and the things we're talking about, there's really no tax issue related. Right now, the federal estate tax exemption is $12 million. So unless you're worth at least $12 million, there are no estate taxes and there's really no tax issues associated with that. I do know there have been talks about rolling that back, and it's set to roll back automatically in the next few years. But even if it rolls back, it's usually around $6.5 million is what it would roll back to.
Okay. Yeah, we don't typically write life insurance policies that large, but it happens.
Right.
It definitely happens. What would happen in the situation if we just didn't list a beneficiary at all?
Then there would be a probate required.
Okay.
And if you had a will, then it would pass according to your will. If there's no will, it would pass according to the intestate statutes. And that usually is split between a spouse and the children. No, it does not always go to the spouse. A lot of people think that. And the other kicker, though, is it also may depend on your policy. I have seen some policies that if there's not a beneficiary listed, it says it goes to the next nearest living relative, and then the policy defines what the next nearest living relative is in their order. But if there's nothing like that, then it reverts back to the estate and a probate would have to be started.
And you may not even like your next of kin. That would be bad.
Yes.
That would be an awkward situation.
Well, I actually had it happen where the husband and wife had actually not gotten a divorce, but they had separated, and there was domestic violence involved. He was an undocumented person. He was sent back to Mexico. The wife died, and she had one daughter that was 19 that was not the husband's, and then another child that was 8, and the 19-year-old was taking care of the 8-year-old and could not access the life insurance policy.
Oh my goodness.
Because the policy defined the next nearest living relative as the husband.
The spouse.
And I've seen that happen too. Megan and I had this discussion. When we do a group meeting and we're going over, this is option period, this is, whatever, please make sure your beneficiaries are up to date. That was another question that I was going to ask you. If the separated is a good thing because you never really think about taking someone off a life insurance policy. But I've even had exes that they're truly divorced, but on that 401k or that whatever, they never updated it. Now they're remarried, but if they leave their ex on there on life insurance, it's going to the ex. Is that correct?
I cannot tell you unequivocally.
Okay.
I do know that in Oklahoma, that if the ex is on a will and you do not execute a new will, it is if the ex-wife predeceased you.
Oh, okay.
She would not be entitled. I have not looked at the issue of life insurance. I do know on 401ks that there are some ERISA laws that affect those. And so I actually have a case right now in which they were in the process of getting a divorce. Someone else was on the beneficiary designation, but because the person was the spouse, I believe she's going to be entitled to that policy or to that money. So there's a lot of different laws that can come into play that might affect that.
Especially with tax qualified money, you've got a lot more T's to cross and I's to dot. But I mean, you will agree with me that it's always a good idea to stay on top of your beneficiaries at least annually. Because like you said, they're not irrevocable. I mean, so if you start out and you put someone down or a spouse down or whatever, I get that a lot. It's like, okay, if I put this person, can I change it? Right. So, and you can change those at any time during the year.
Absolutely. You can always
events.
change a beneficiary. And I do a lot of estate plans, and that's one of the things we go over. What life insurance do you have? Who are the current beneficiaries? And I can't tell you how many people. One can't even tell me, I think I've got life insurance with this company. I don't know who the beneficiary is on that.
Yeah.
They don't even know.
It's, so scary.
Yeah, I get that. I get that a lot too. You brought up a word earlier, Monica, that I think it would be worth some time looking into. Can you define probate or help our listening audience understand probate just a little bit more?
Sure. A probate is basically a court proceeding that determines who inherits your estate.
Okay.
A lot of people think if they have a will, they do not have to go to probate. That is not true. The probate court merely determines whether or not the will is valid. And I can tell you a lot of people print wills off the internet and then do not fill them out correctly, and they are not upheld in court. I would say at least 75% of the time an online will is usually thrown out because it wasn't
goodness.
executed validly.
Wow. Okay.
And so the probate proceeding determines who inherits your estate. If there is no will, then we revert to the intestate statutes. A lot of people think if they're married, then it goes to the spouse. That is not true. It depends on whether it was marital property purchased during the marriage. It also depends on whether there are children with outside the marriage with other people that are stepchildren. But generally, there is some formula in which the spouse and the children inherit the property.
Okay. That's really good to know that, just because I think that is common thought process is it just is going to go to my husband or my wife anyway. So why do I need to take the steps to fill this paperwork out or to set up a living will and trust and all of those types of things?
Right. Now, if it is a joint account or a spouse is on a beneficiary designation, those are things that pass outside of probate.
Okay.
But anything that is in that person's name only with no beneficiary designation would have to go through probate. The other thing is property, like a house. Most people think if both the names are on the deed, that's all they need. Mm-hmm. That is not correct. It has to have what we call the magic language of joint tenancy with right of survivorship. If it just says and or just says and doesn't say joint tenancy with right of survivorship, then if one person dies, that person's portion has to be probated.
Wow.
Scary stuff.
It is scary stuff.
Okay, Monica, you're scaring me enough. I need to come see you. How do our listening audience get a hold of you if they are in the situation that they need to take the steps to set up this trust situation that we just talked about?
Well, they can reach me at 918-512-1351, or they can go to our website, which is maplelaw.com.
Perfect. Thanks so much for your time today.
Thanks for having me.
Disclaimer. Subjects that we discuss on the podcast are meant to be used as topics of conversation. All figures given are sheer examples. All information is subject to change and probably has changed since the airing of this podcast. Rates and figures change depending upon the demographic in which you live. Anything discussed in this podcast is our opinion. We do not represent Medicare, any governmental agencies, or any of the carrier partners on the show. Each person should do their own research on the various websites to ensure accuracy.